Good afternoon, everybody. This is Omar Serrato with the Tilted Lawyer Podcast, and I can't believe it. But it happened. Sarah Boone, in all of her efforts to obtain attorney number 9, after being appointed 8 previous attorneys, all of which ended unceremoniously with them withdrawing for various other reasons because she was calling her attorneys buffoons and duds and this and that. Well, there is a guy out there in Florida, goes by the name of James Owens. He has answered the call and he is ready to take on her case. And we're going to talk all about it coming up next. Well, guess what's bound to happen? Sarah Boone, when she put out her advertisement that she was going to, she was seeking an attorney. And then you saw her flailing about in court trying to represent herself, facing basically a murder charge, representing herself pro per, going up against the state, trying to find a way to maneuver around legal procedure and litigation and discovery and all these kinds of things. She said on multiple occasions, at first, I recall when her 8th attorney withdrew, she had stated, well, I don't want her to withdraw, but I guess I have no choice. I'm going to be in pro per. She had tried to get the case dismissed a couple of different times following filing her own motions to no avail. Motion after motion to try to get this and that with discovery, raising issues with the court. How am I supposed to review all of this discovery in the confines of my jail cell, asking for special accommodations to be made for her so that she could prepare, I guess, on the prison issued laptop that they had granted her with, I guess it must have been limited Wi-Fi access. They were storing gigabytes of information and discovery on these thumb drives that she was trying to parse through and examine. And they've been litigating this case now for a period of years. It's not like any of this was brand new. The judge got fed up and he said, look, I'm starting to think that this is a ploy. I'm starting to think that you're purposefully delaying these proceedings by causing strife in your relationships with your attorneys, and enough is enough. I'm setting trial dates for October. They will not be continued under any circumstance whatsoever. And that's just that. So if you're lucky enough that some poor chap over there wishes to try to take on the challenge of representing you in your case, then hey, more power to him. But he should know, because I'm stating it right here, he should know that there will be no further continuances in this case. And so what happens is, James Owens, he is not a local attorney to where Sarah Boone is being tried. He lives hours away. I'm not familiar with the Florida terrain or landscape, believe it or not. I've never been. But he's an hour's drive, not an hour, but multiple hours drive away from Sarah. He happened to be in town on a case that he was working. He decided to pay Miss Boone a visit. Now, he is apparently a consumer of court TV. He's been following this case along with all of us. He says that he watches these YouTube channels, mine being one of them, that covers these cases. And he's aware of what Sarah Boone has been facing. He's been aware of this case for a long time. He wrote a letter to Sarah. He said that he went through a third party, I guess, to vet him, to figure out whether or not he was some guy, whether or not he was an actual attorney or just some guy trolling. As I'm sure Sarah had probably good number of those. He ultimately pays her a couple of visits. I think it was like 4 separate visits, visiting her for hours at a time and impressing upon her not just his knowledge of the case, but his knowledge of the legal system over there in Florida, his ability and skill set, his wherewithal to be able to try these major cases. And he convinced her enough that, you know what, he's the guy for the job. Now, I'm not sure how much convincing it really took, because I feel like we were at a point where Sarah was already pretty mentally taxed from this case, in over her head, didn't know what she was doing, was wanting to get motions out, didn't know how to write the motions, was wanting to do certain things procedurally, had no idea how to procedurally do things. And so the fact that any legitimate attorney would jump to the call must have been a godsend. One of the things that Mr. Owens employed in his, I guess, his sales pitch to Sarah was he wanted to take on the role of the prosecutor and give her a feel for exactly how her arguments were going to play out in front of a jury, with the prosecutor asking the questions. It was something that I had opined that I think that one of her previous attorneys had tried to do that. It was something on a previous show around the 4th of July that I had mentioned I would do if I were representing her and prepping her for trial, because she has to understand, if she has these arguments that she wants to make, she has to know how that's going to be attacked by the prosecution and how that's going to fall on the ears of the jurors. So inevitably, this guy Owens, he employs this tactic, and he proceeds to beat her up for a period of hours, where she starts to gain his trust. And there was some back and forth whether or not he's going to actually take on the case. And we're going to listen to an interview that he gave with Vinnie Politan, I think earlier today, where he was kind of describing the process of how he went about taking on this case, because it's worth noting. What are my initial opinions of Mr. Owens? I think that he's a more than capable attorney by the judge's recitation of his experience, because the court vetted him. They weren't just going to let anybody take on a murder case on the eve of trial. We're about 38 days away, 37 days away, whatever number it is. He's tried hundreds of cases to trial. He's been around for a really long time. He presents very well in court. He's the exact perfect person that I would pick to represent Sarah if Sarah Boone was like my mom, or a cousin, or a family member, and I cared at all about her. He has this appearance of empathy and compassion. And regardless of what you think about the merits of Boone's defense, because there's not a whole lot of defense when you really look at the meat and potatoes of this case, he deserves to be represented. Nobody deserves to have to represent themselves in a murder trial all by themselves, in pro per, if they really don't want to. And I'm not saying that she didn't put herself in that position, but I'm really glad, for a million different reasons, most of which I stated on my last show, that she's at the very least going to have a fair shake at this with a competent attorney that's going to advance her arguments in a way that may end up, best case scenario, convicted of second-degree murder in a way that allows her to possibly, maybe, be sentenced to credit for time served, thereby being released upon the outcome of the verdict. I think that's probably best case scenario for her. There's not going to be an acquittal in this case. What the defense is going to go with, what Owens is going to go with, is what everybody has suggested: the battered spouse syndrome, which is a real thing, because I remember talking about it on a previous show. What is the merits of a battered spouse defense? You have Sarah Boone, and if you're familiar with the case at all, if you're not familiar with the case at all, go back and watch my video where I kind of go down all of the facts of the case, and I break down what her defense might have been or may be at trial. We go through that exercise, but it was a night where she was playing hide and seek with her fiance, as you know, couples are wont to do. And after copious amounts of drinking, to where she was full plastered. I mean, slurring her words. I mean, she was stumbling about. Who knows what shenanigans ensued that night, and what led him to zip himself into a suitcase. I don't buy for a second that he didn't voluntarily get himself or step into the suitcase himself. But I feel that the defense is going to be this: that in the heat of the moment, in the midst of this alcohol-induced state that they were in, that Sarah, recognizing the situation, recognizing the scenario, had a mental break induced by alcohol and found herself in control of this man whom had abused her for years and years and years, leading up to this final moment where she now has him trapped in a suitcase and she has the key and he's stuck in there and he can't do anything about it. And in her trauma, she dumps all of her trauma, all of her psychological damage upon this man and taunts him relentlessly and films herself doing it and doesn't remember that she did that. Come to find out that she actually recorded herself in the middle of a police interrogation later the next day. So that is her defense, that she was so overcome as being the victim of domestic violence over the period of time that it led her to act as if nobody else would have acted, as if she wasn't a battered spouse. It caused her to behave in this way that led to the death. It doesn't exonerate her, but it's her best chance. And so what is the caveat to that? The caveat to that is it appears that if you follow the trail of arrest records, that they were both not convicted, but they were both arrested for multiple acts of domestic violence. There was an occasion where the two of them had a domestic incident and she had called the cops on her boyfriend. Boyfriend said that she was the one that attacked him. And then they ended up both going to jail. The charges were dropped on both sides. And so it's not just domestic violence only as to boyfriend attacking Sarah. It goes both ways. And if it goes both ways and the jury thinks that it goes both ways, well, then how are you going to prove battered spouse syndrome? That is a fly in the ointment that Mr. Owens is now responsible for solving. So that is the defense. Now, the other thing that Owens, I think that he assumed, is that now that he is on the case and is going to take control of the situation, he is now the white knight pulling up to the courthouse to rescue everybody from this very chaotic situation. And knowing all of that, that the judge would, in his good graces, decide to grant a continuance to allow for adequate preparation to be able to present those defenses. If you're going to prove battered spouse syndrome, you're going to have to get expert witnesses to testify to those things. And another thing that's problematic to it is if he's going to use that as a defense, he has to formally notify that in writing through a filing in the courts that the DA has access to. And he's only got about like 5 more days to do it. And if what he was saying is, if you're going to make that filing, then it has to be based on a good faith belief that battered spouse syndrome is a viable defense. And he was arguing, how could I possibly make that argument in good faith if I haven't even spoken with an expert witness that I could point to as this is the person I'm going to call that's going to pontificate to the jury why Sarah Boone is the victim of battered spouse syndrome and why this jury should consider that in deciding whether or not she's guilty of these charges. Now, you say that, the prosecution's retort to all of that was, look, they've had plenty of time. It's not like we didn't know that this was a thing from the 8 other attorneys that have been involved. There have been multiple psychologists that have been interviewed, and all of that is in the thousands of pages of discovery. It's all been handed over to Miss Boone. And so good luck. You wanted this case. Have at it. I do believe, not that I believe, I know that Mr. Owens really expected the judge to grant him a continuance. Problem with that, and I've been involved in cases like this where I have taken on cases that have been continued a number of different times because clients keep on firing their attorneys. They don't like this one, so they're going to get another one. Then this guy shows up, they don't like the color of his suit or whatever, so they fire him, they get another one. And then we go on and on like that. until a judge says, look, I just want it on the record right now. If you do this again, there will be no further continuances. And then they do it again. And then new counsel wants to come in on the case. And then they ask the judge for a continuance. It's like, look, you're the one that took on this case. You would have done well to review the docket. And if you had reviewed the docket, you would have noticed that on a minute order dated June 5th, I explicitly stated that any attorney coming in new on this case would not be granted a continuance just for the sole purpose of your new counsel coming in and now you need to get caught up to speed. So you knew what you're doing. I trust that you reviewed the docket and you're here now. We'll see you in October is basically how it went down. I think that we should listen to some of the audio from Miss Boone's new attorney, where he was specifically asking the judge for a continuance. Let's listen to some of the audio of that.
Representing yourself pro se, I can't imagine JAC is going to change their position with regard to those costs since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it could just be the order can be modified to extend to you as counsel for Ms. Boone. Thank you. All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was almost ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. If that's just going to take a little bit of time, Judge, I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance.
By the way, James Owens is absolutely right. That's about how long that's going to take. It's a completely reasonable request. And under any other circumstance, it would have been 100% granted. No questions asked. Of course, you got a murder case. You're going to need to prepare for this. But in this case, Sarah Boone has shot herself in the foot through her conduct with 8 other attorneys. I mean, this is a case that originated, when was it, like back in 22? And we're pressing up against 25 here. We're almost 3 years into this, and we're still not. We're still asking for continuances for a trial. Look at the judge's face. The judge is like, he was so ready for him to make this motion. You're going to see him say, you know what? I heard you. Then he goes to the people. The people says, well, they want to continue this. I don't agree. It's been long enough. Then the judge says, yeah. And he's going to cite all the reasons why he's not going to do this. And a lot of that is based on Sarah Boone's conduct.
The thing about it is Mr. Padilla has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the sheriff's department has been transcribed. They haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So because of that, but ultimately because, yes, can I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready.
No.
And so that's instrumental in our defense.
You're not wrong.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys. And in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file the notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why this Florida Supreme Court.
His judge is kind of a dick. He's basically saying is he's using that rule to say that, hey, yeah, so the legislature, they contemplated that 30 days should be sufficient. And so you have over 30 days, so shouldn't that be enough?
The court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, I'm going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brandon needs more time.
All right, thank you. State anything else?
No, you're
All right, thank you very much. All right, Mr. Owens, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you've met with Ms. Boone on 4 different occasions. that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause. And such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert. And as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and had the opportunity to review those.
All right. So he denied his request for continuance, I guess, is the long story short of that. And then he's stuck with this case. This is him talking to Vinnie Politan about what possessed him to try to take on this case and, how it all went down. And I am going to play a little bit of that.
The court's decision, but that left her.
So he's in this interview right now with Politan, and he's just kind of talking about how he's observed the case, and he's talking about how it's unfair that she was going to have to represent herself in this murder case that was potentially going to be like a 3 weeks long trial, it looked like, and he's coming to answer the call.
Facing a murder charge without a lawyer, which is unheard of, I think. And so, I watched for a while, and then I saw the ad on your show. And I think that you had said something implying, hey, who's gonna take the case? What lawyer in Florida is gonna pick up the torch, so to speak? And I think you had somebody on, maybe it was a lawyer from the Northeast, and I think I remember that lawyer saying, man, if I was a license in Florida, I'd take the case, under that scenario, because she really needs a lawyer. Everybody needs a lawyer. And so the ad came out, and I sat there and waited for 3 or 4 weeks. I can't remember now how long I waited, but I was thinking that a lawyer out of Orlando would pick up the case. Somebody would think, hey, this is not right. There's no way she's going to get a fair trial representing herself. It's unfair. But there's a gap in the system. The judge made a decision based on her conduct, that she had forfeited a right to a lawyer. I believe that's where the private sector has got to step in. Somebody in the private sector in that situation, and it's rare, should step in.
So he's talking about that, and then he starts talking about how he started to build a rapport with Boone and the way that he did that.
And spend Tuesday talking to her, and she agreed. So I drove down Monday after work. Tuesday morning,
can you describe that meeting without, I know attorney-client communications is off limits, but how would you describe that meeting to someone? Like, was it different than meeting other clients for the first time?
The first meeting?
Yeah.
No, it was, it was a 4-hour meeting. I usually don't meet with clients in the jail for that long. So I gave her a chance to talk and just listened for a long time. She had a lot to say. Obviously, she's been in jail for 4 years. And, we had a good meeting. Just, again, I think she has trust issues because she felt like she did have some good lawyers that were on her case and just withdrew because they would get in some arguments about issues, I guess. And so she said they wouldn't even tell her anything at the jail, but the next thing you know, she would, be sent to court and the lawyer had filed a motion to withdraw. So she didn't, trust the lawyers because she didn't know who to trust. She'd been with so many. So a lot of it was just trying to build trust with her. After she talked a little bit, I told her a little bit about myself. So really feeling each other out and trying to build some kind of rapport was the first meeting, which was about 4 hours. But I think early on in the case, I was able to persuade her that I knew what I was talking about because I was prepared. When I got there, I was prepared, and I played part of that 4 hours. I played the prosecutor, and I pulled out the jury instructions, and I made an argument as a prosecutor would make to a jury, and I had her sit there and listen to it. And I think that was effective. I don't think she had anybody ever do that to her and explain it to her that way of how it would play out in court.
When you do that, when you do stuff like that with clients, it really, really is powerful because I don't think that they understand sometimes how devastating it's going to look when the other side makes all of the arguments that everybody else is thinking, and you're just kind of sitting there by yourself in your own thoughts thinking, oh, that's not going to matter because of this, this, and that. Well, when they put it all together and connect the dots outside of your perspective, just from an objective perspective, from the other side, it's really eye-opening. And a good attorney could gain control of their client simply just by doing that. And that's what this guy did. Now, the other thing he spoke to that I thought was interesting was just how overwhelmed she was trying to represent herself and the effect that it was having of her. Let's take a listen to that.
Called the prosecutor and said, look, we've reached an impasse. There's no agreement, and I'm not going to be representing her. And I went home. And I want to say a couple of days later, Sarah called me, and we talked some more. And I told her Vinny,
So, but at this point, she's now reaching out to you because she wants James Owens to represent her.
Well, we did connect. And I think she was overwhelmed being her own lawyer. She was stressed out.
Yeah.
She had all this discovery that she was trying to go over. She didn't know what she was doing. She didn't know the rules of procedure, rules of evidence. And she had told the judge, I think they'd had a couple of hearings on some issues, and she said, Judge, this is not fair. I don't know what I'm doing. And the judge kept saying, well, I'm sorry, ma'am, but this is your position. So I think she was just thankful that I came down to see her. We had, some good meetings. So I think she really needed some help. So
yeah, that's that is James Owens, new attorney. He went on to Court TV today and did an interview with Vinny Politan. If you haven't already done so, you're going to want to go down over there to check that out and listen to that interview in its entirety. It's only like 15 minutes or so, but it's worth a listen just to get a feel for him as an attorney. And I'll tell you what, he's probably my favorite kind of defense attorney insofar as that he's not flashy. He doesn't appear to have that big of an ego. He is who he presents to be. He's very skilled in the courtroom, very experienced. And look, he was hoping, expecting that this trial is going to get continued, and it's not. And it's not like this is his first rodeo. And so, yeah, it sucks. But if anybody could be prepared in 30 days for this level of trial, I would trust that guy. Does that mean she's going to win this trial? No, it doesn't. It doesn't mean that. The facts are still what they are. And juries, sometimes, no matter who your counsel is, they might like you and all, but if the facts are against your client, then there's not much you could do about it. The reality of it is she is on video suffocating her fiance in a suitcase. It's tough to overcome. Battered spouse syndrome or not, it is an uphill road to climb. But I'll tell you what, she's got a much better chance now than she did just 5 days ago. And so we will leave it at that. Folks, that's all I have for you today for the podcast version. You might want to come over and join us on the YouTube channel for Poker Night. I'm going to have a Lauren Knighty on there. We may have Schnitzel Ninja. We're going to have Pam the Starchasm in there. We're going to have maybe Bruce from Oregon, Brad IT guy, and maybe a couple of others. But it's just going to be some shenanigans. We're going to be shooting the breeze on a Wednesday evening because it's that kind of a night. I hope to see you guys all over there. It's completely free to whoever wants to show up. You don't have to be a member to be in there. I hope to see you all in there. And at any rate, I will see you guys over on the YouTube channel and on the podcast tomorrow afternoon. Love you lots. Be safe out there. Bye-bye.